Yes, Your Honor, they have.
Go right ahead. Is it marked as an exhibit or not?
No, Your Honor, it's part of the testimony.
All right, ma'am, consider yourself sworn and you may proceed with your question.
Please state your name for the court.
Jennifer D. Lorian, Lorean.
And what do you do for a living, Ms. Lori?
I was part of the white collar crime division of the FBI for 25 years. During that time, I worked in hundreds of undercover operations dealing with crimes such as bribery and extortion, and both as an investigator and a senior agent. And now I'm the owner and chief auditor for my company, Greylord Strategies Incorporated.
What does your company do, Ms. Lori?
For the past 5 years, which is when I started my company, we consult with various government and police agencies on proper protocol for undercover operations and investigations, as well as other investigation strategies at a federal, local, and state level.
What's your educational background?
I have a bachelor's in applied mathematics and statistics from Johns Hopkins, my JD from University of Virginia, and an LLM from Harvard.
Do you have any publications?
Quite a few actually, with 2 colleagues who are forensic psychologists. I have brought my expertise on police procedures to bear on their knowledge of social psychology, and together we have produced 2 peer-reviewed articles on the bias of forensic testing.
What do you mean by cognitive bias?
Okay, for example, the lab that is used by the MSPD will receive a portion of the court costs, and this is well above the restitution fees for any conviction in cases where their technicians are used to testify, and this can alter the incentive of criminalists when considering the fact that they will profit from any conviction.
And,
Do
why do you,
you mean that the actual police department in this case can make a profit if the prosecution is successful?
yes, Your Honor.
Okay, thank you.
Why were you called for this case?
My company was contacted to investigate the procedures used by Midland State Police Department that led to the arrest of Chase Covington and Avery Bancroft.
And what were you asked to do?
We were asked to provide 2 things. Firstly, an expert opinion on procedures used by Midland State Police Department that led to the arrest of Chase Covington and Avery Bancroft. And secondly, give an expert opinion on Mickey Keenan's investigation in light of our 2014 audit report.
What documents, if any, did you review?
I received the audio files and transcripts of Mickey Keenan, Corey Hyde, and Chase Covington. I reviewed those as well as the email correspondence amongst them all.
Any other documents that you reviewed to draw your conclusions?
My company, Greylord Strategies, was hired to perform an audit in 2014. I used this audit as the basis of my investigation, although I also received the affidavits and reports of Mickey Keenan, Corey Hyde, and Pat Skaworski, and I'm familiar with exhibits 16 to 25.
It's the first time the court's hearing Pat Skaworski, who's next.
Yes, Your Honor. She means Pat Sikorsky, the expert witness that the prosecution called.
Okay, gotcha.
Yes, Your Honor. What was the purpose of your 2014 audit?
Well, back in the 90s, most of the country adopted the undercover guidelines put into place by Congress, and I was hired to assess how MSPD was following these guidelines.
What are the undercover guidelines?
They are a set of rules and procedures put into place to protect agencies and individuals from things such as misconduct and entrapment while
Objection, Your
undercover.
Honor, you're saying to the guidelines of the MSPD?
Your Honor, if I may.
Go ahead.
Under Rule 8037C, an expert witness may use testimony that is otherwise trustworthy.
Is she going to be basing her opinions in this case in part on these published guidelines?
Yes, Your Honor.
Any response to that from the prosecution side?
Court's indulgence, Your Honor.
Is the rule you cited, sir, part of the materials that was presented to the court on pre-trial?
No, Your Honor, it's part of her case. It's part of her report that she issued.
No, the rule of evidence that you're citing, has that been provided to the court?
The rules of evidence?
Yes.
Yes,
Let me just take
it
a
was-
quick look. I'm familiar generally with the exception that an expert can rely upon information that may not ordinarily be admissible if it forms a basis for the expert opinion, and I've heard the expert saying that it is gonna be form a basis of the expert's opinion. Go ahead, Madam.
Your Honor, the opposing counsel hasn't laid foundation of whether the MSPD's guidelines are trustworthy. And there's no record that this record is a regularly kept matter.
That's the purposes of the 8037C, Your Honor.
Let me take a quick look at this. See. 807C or 8037C?
8037C, Your Honor.
8037C. Are you going to be introducing the rules and guidelines themselves as evidence in this case?
No, Your Honor, we were just gonna have the testimony to that report.
Your Honor, this doesn't lay foundation of whether the guidelines are trustworthy.
Your Honor,
Hang on, C says neither the possible source of the information or other communication circumstances indicate a lack of trustworthiness. Now, from the prosecutor's side, as an officer of the court, do you have any information that these congressional guidelines indicate a lack of trustworthiness? Because that's your objection, if I understand, that there's been no facts that establish that congressional report and guidelines are trustworthy. I want to know as an officer of the court, do you have any information that
That's my objection. We don't know if these guidelines are trustworthy.
well, then you cannot be expert witness to provide testimony as to the reliability and the trustworthiness of the guidelines for the scientific community that she's involved in.
Yes, then I ask-
Establish a foundation.
I ask opposing counsel to lay more foundation.
That's an appropriate response. And you lay a foundation that the congressional guidelines are trustworthy and accepted in the professional community of this witness practices.
yes, Your Honor.
Go ahead.
So what are the undercover guidelines?
The undercover guidelines are a set of rules and procedures which protect agencies as well as individuals from things such as misconduct and entrapment while undercover operations are occurring.
And what are the benefits of an undercover operation?
Since it is highly unlikely that someone will turn themselves in after being involved in bribery or insider trading, it is very often hard to actually prove that a crime happened at all. So undercover officers give law enforcement a pair of eyes on the inside of a criminal enterprise, and that is priceless information.
What are the risks associated with undercover investigations?
An agent can improperly carry out an undercover investigation, and
Hang on a second. I still have the objection of the prosecutor before me. Have you finished laying the foundation that you claim establishes the guidelines are trustworthy or not?
I can ask one more question on that matter.
On that, I need you to specifically address that.
Yes, Your Honor. How did you discover the undercover guidelines?
well, I wrote up the undercover guidelines.
You were the author of the guidelines?
Yes.
The congressionally approved guidelines?
Yes.
Oh, okay. Go right ahead.
With correspondence with the Attorney General.
Okay, go ahead.
So, what are the benefits?
Since it is highly unlikely that an individual who has been involved in bribery or insider.
Just a minute, counsel. I don't need to know what the benefits are. The issue before the court is to establish that they're reasonably reliable in the professional community that this witness is with.
Oh, yes, then.
So I need you to concentrate on that aspect of the foundation.
Okay, Your Honor, then, has the witness established that by saying she authored it with the Attorney General?
Counsel, has the witness established that or not at this point?
No, there is no foundation.
I haven't heard it yet. And what I need to hear is a foundational element from this witness that these guidelines are accepted in the community and relied upon in the community that she works in. I haven't heard that yet. I don't know if she's gonna say that, but that's what's missing from the
Yes, Your
document.
What can you tell us about the undercover guidelines in your community?
our community, the undercover guidelines have been applied by all other, official standpoints. And I worked with the Attorney General to compose these undercover guidelines, and the district attorney is aware of these guidelines and approved these guidelines and worked with me, and has also enforced the implementation of them in Midland.
All right, are you talking about the state attorney general or the US attorney general?
The district attorney,
For Midland,
well, the federal attorney.
okay. From the prosecutor's standpoint, if the US attorney general of the United States of America has approved these guidelines for law enforcement agencies, hasn't the defense established the trustworthiness of those, the risk of those, in this case, through this witness?
Your Honor, this is not according to a report and therefore is not true.
Look, wait, you didn't answer my question. Do I need to repeat it again?
Yes, please.
Your objection is that these guidelines are not trustworthy.
Yes.
To me, trustworthy means that they are generally accepted within the community that uses these guidelines. And the community is the law enforcement community.
Yeah.
These are guidelines used by law enforcement communities to ensure that these undercover operations proceed smoothly and to avoid problems. If the Attorney General has accepted these guidelines for use in the federal system, then hasn't the trustworthiness been established?
Yes, Your Honor.
Okay, then very well, then your objection is overruled and you continue.
Yes, Your Honor. What are some of the recommendations made in your 2014 audit?
I made the recommendations that the MSPD record any and all training of undercover officers as well as confidential informants, documentation of correspondence between undercover employees and informants, especially with the risk of OIA and entrapment existing, strictly follow the undercover guidelines for Group 1 and Group 2 UCO, and make sure that all approvals received for appointments before they begin.
Your Honor, I'd like to request that the witness step down to make use of the demonstrative. Now, Ms. Lorian, what can you tell us about the results of your 2014 audit?
Well, from my results, I discovered that of the 40 undercover operations that occurred, 70% of these had authorization-related errors, and 50% of these had at least a single violation of undercover guidelines.
Objection, Your Honor, to the grounds of hearsay, this exhibit is not in evidence.
Your Honor,
The exhibit is not an evidence, it's not proved in evidence yet.
yes, Your Honor, this is directly from her report, which references the undercover guidelines, which was a previous objection to hearsay. It's just a follow-up to that report. These are her findings.
The undercover guidelines is not that document, correct?
No, these are the results.
Her objection is to her testifying as to that report that's used for demonstrative. Did that report come from, is this demonstrative evidence created from her report?
Yes, Your Honor.
Has that been exchanged with the defense counsel?
Yes, Your Honor, we discussed it.
Okay, so the objection is not to her conclusions, but simply that she's using this as a demonstrative evidence?
I ask that there's more foundation laid for this,
Your objection, is it to her testimony or to the use of this exhibit?
to her testimony.
Okay. It's her audit that she did, and as far as I know, she's accepted as an expert in this case, is that correct?
Yes.
There was no challenge to her qualifications at this point, right? My understanding is the initial following. I don't think she's allowed to give her opinion in this case.
Yes, Your Honor.
And in 5 of the cases, the requisite approval was not obtained for operations involving sensitive circumstances.
Thank you, Ms. Lawyer. You may return to Your Honor, permission for the witness to return to her seat.
Sure, go right ahead.
Now, we'd like to discuss these recommendations you made individually. What is OIA?
OIA means otherwise illegal activity. For example, an undercover officer cannot bug someone's phone without legal precedent, and proper authorization is needed for OIA, and in this case, Group 1 UCO.
What is a Group 1 UCO?
It basically means that since Covington was a political official, his investigation qualified as having sensitive circumstances. sensitive circumstances involve any public official at a federal, state, or local level in any matter considering corruption, and thus constitutes a Group 1 UCO. And that means that the operation has to be authorized by the highest level of authority within the investigation and the agency, as well as have the appropriate documentation.
What kind of documentation?
The investigation and operation needs to have an application which describes the operation in full, as well as the scope, duration, and cost of the operation. Additionally, the application needs to include a letter from the prosecutor's office stating that the office has approved the proposal and that it is legal, that they will prosecute any meritorious cases, and that they view the benefits of discovering or prosecuting any criminal behavior outweigh any direct costs.
Now, you previously mentioned training is required for undercover agents. What can you tell us about Mickey Keenan's training?
Mickey Keenan was not trained in proper documentation, proper implementation of the READ technique, or how to avoid victimization of innocent parties.
You just mentioned the READ technique. What is that?
The READ technique is an investigation technique, and the premise behind it is that the more comfortable the interrogator makes the suspect, the more likely the suspect is to confess.
Now, Ms. Lorien, what can you tell us about Mickey Keenan's ability to comply with the undercover guidelines due to his lack of training?
After a thorough investigation, I discovered 0 authorization documents, and that the district attorney had absolutely no idea about the operation until April 2015, when the MSPD asked for warrants, and this was 2 years after Mickey Keenan stated that the operations began. And thus, in my opinion, this shows a complete lack of ability on Mickey Keenan's side in terms of following the undercover guidelines.
No further questions, Your Honor.
Cross-examination.